Thank you very much, Kristen, for that very kind introduction. And I just want to thank again Nora and all the organizers for this superb organization. They have spent clearly countless hours, and it's already paying off if you've seen the website and been able to enjoy this content already. I noticed that screen sharing has been disabled, so I wonder if somebody could make me a co-host or enable me to share my screen. If you haven't seen the posters yet, I also recommend that. The postgraduate workshop on Friday was really excellent. Okay, the title of this conference contains a series of keywords: market, economies of space and time, competition, transfer, and of course, periodicals. These terms can and will push our conversations in multiple directions, but since I have the honor of being the first speaker of the week, I wanted to find a way to discuss these terms in relation to my own research on the history of copyright, in hopes of inspiring discussion of what I see as some of the fundamental features and practices associated with periodicals in all their variety and in different historical periods. In response to the keywords, then, I offer this as one possible starting point. The business strategies and cultural practices of periodical publishing have often reflected the fact that periodicals are situated in relation to other publications in space and time. Periodicals are in dialogue not only with each other, but also with books, correspondence, artworks, stage plays, public lectures, and so on. But despite their frequent overlap and symbiosis with other media and cultural forms, periodicals share certain traits and generate specific practices that differentiate them from other cultural forms. Of course, there is a tremendous variety of periodicals in terms of format, genre, interval of publication, price, target audience, and so on. I would indeed put price currents and gazettes under the umbrella of periodicals with scientific journals and literary reviews. The reason that periodical studies is thriving as a field of research is owing in part to this variety and the need for nuance and precision when we discuss the production, circulation, and reception of all these kinds of periodicals. But I also think there's something to be gained by stepping back. So my definition for today is broad and of course open to debate, that periodicals are ongoing publications issued at regular intervals, although there are exceptions to that, and which contain features that make them recognizable as part of a series, such as a stable title and standard layout, the use of numbering, the inclusion of certain kinds of content in a particular order, and so on. This is not the same definition that a library cataloger might use, for example, because it's one that includes newspapers, which are often cataloged separately from other periodicals. Periodicity can, of course, be seen to have myriad cultural effects, and that is a fascinating topic of study and one that members of ESPRit contribute actively to. But today I will focus on the somewhat more sober question of copyright. Periodicals and contributions to them have historically had complex and problematic relationships to copyright and author's right. Here you see the basic legislative chronology for the three countries that will feature in my discussion: the United Kingdom, the United States, and France. My examples will come mainly from the period shown here, that is to say the 18th and especially the 19th century, but of course this story does not stop in the early 20th century, and many of these issues are ongoing. The chronology for the UK and the US might lead us to conclude that the history of copyright for periodicals is the history of delay, as if copyright finally caught up by providing periodicals with the same sort of protection that previously existed for books. But such chronologies are misleading. Judicial recognition of copyright for writings and illustrations in periodicals was often secured long before these categories were mentioned in the statutes. Moreover, just because a law was on the books does not mean that authors and publishers made extensive use of it, or that they understood it in the same way as lawyers and judges. In comparison to the rather closed list approach of Anglo-American copyright, the French tradition of authors' rights has often been seen as more universalist and expansive. The French Revolutionary Decree of 1793 asserted that property adhered to all kinds of writings, rather than listing specific genres or formats. But even in France, the question of whether contributions to periodicals constituted literary property was subject to debate and litigation. And it was only when individuals went all the way to court that judges had to clarify what kinds of articles were within the purview of the law. I think it's useful to step back and think about some of the fundamental characteristics of periodicals that have created challenges for copyright law, and in some continue to do so, suggesting that copyright is not a one-size-fits-all principle, despite the universalizing rhetoric that usually surrounds it. First, periodicals are serial works. That raises the question of what is the unit you are trying to protect? Is it each individual issue or something more, which might include protection for the title, the composition, the layout, and so on? It also raises the question about how to register and deposit the periodical. And depending on the periodicity, these requirements could be more or less onerous. A daily paper that appeared in multiple editions per day was much more difficult to deal with than a monthly magazine. Second, periodicals are collective works. The fact that multiple people contribute raises the question of the allocation of rights. What belongs to the author and what belongs to the publisher? Does the editor have separate rights? Who has rights over anonymous and unpaid contributions? Third, periodicals are compilations of a particularly heterogeneous sort. They may include both original and unoriginal material in a range of genres. What parts of a periodical constitute property? Should the rules about copying be the same for news reports as for fiction or criticism? What about political discussion or editorials? Moreover, within periodicals, some genres are perceived as more time-sensitive than others. For example, commentators might remark that literary criticism or biography had an enduring value that news reports did not, suggesting different rules should apply depending on the perceived potential longevity of the material, some forecast into the future. These judgments could work in tandem with aesthetic arguments about the amount of creativity or intellectual effort required of the author, and political arguments about the public interest in facilitating the circulation of knowledge and culture. The timeliness of news in particular raised fundamental questions about the purpose and scope of copyright, a topic that I explored in depth in my book, Who Owns the News? Finally, periodicals have always existed in relation to other publications situated in time and space. Such relationships are key to understanding disputes over copying and efforts to exert control over the circulation of texts and images. Although my focus will be on relationships among periodicals, interactions with non-periodical forms were also important for copyright. In the case of book reviews, for example, how much of a novel could be quoted in the press? Could newspapers print speeches without the permission of the speaker? How could an author of a serial work reserve the right to publish it in book form? And so on. These questions and many others were asked, and some answers were given during the 19th century. But today, I'll focus on relationships among periodicals, which are often in dialogue with each other, if not dependent on each other. The mutual benefits of these relationships depend on both geography and time. Copying that might be beneficial or even essential in some circumstances can be harmful or even fatal in another set of circumstances. And since we obviously don't have time to discuss all of these traits that are on this slide, I'm going to focus mostly on the last three. That is to say, how do you determine what parts of a periodical constitute property? How do relationships among periodicals complicate this question? And how does the timeliness of certain kinds of material shape the rhetoric and practice of copyright? So I will present examples from Britain, the United States, and France. The French examples were researched specifically for this talk, and I think they add in interesting ways to the others. But this is also new material, and so somewhat tentative in the French case. I should mention that I'll be focusing on texts. The history of copyright for images has begun to attract scholarly attention. And though this is a topic that interests me as well, I don't personally have sufficient research to be able to speak at length on that today as part of this talk, but we can certainly discuss it. So here we go. The question of how to regulate the market for periodicals predated copyright. In the 17th and 18th centuries, European princes and municipal councils granted privileges that combined official permission to print a periodical with the exclusive right to do so. In a given territory, one individual might have the sole right to print a price current aimed at merchants. Another individual, or perhaps a government entity, might have a monopoly on political news. Yet another might have the exclusive permission to publish a literary journal, and so on. In places where political authority was more decentralized, such as in the Low Countries or the German lands, privileges were often local, but competition could come from periodicals printed in other cities. Printers, writers, and postmasters fought over such privileges, but they were limited to a specific jurisdiction and territory, and could not be used to stop copying or translation of articles from periodicals in other places. This licensing and privilege system evolved and broke down at different moments depending on the place. In Britain, that happened in 1695, and it was no longer necessary to obtain permission to operate a press or to produce a periodical. In London, it became a common strategy to time one's publication in relation to other publications. The choice of day and time could be dictated by the desire to copy from others, so you better appear after them, or to hinder others from copying, so you better appear after them, or simply to avoid direct competition in a particular niche. Here you see the masthead of the Evening Post. Evening Post was both a title and a strategy, closely tied to the postal schedule, with the stated goal of being able to include all the substance of the morning papers with fresh advices, and this compilation would be sent out to readers in the countryside. Some morning newspapers complained that the pilfering of the evening papers threatened their property rights. But ultimately, it was the institution of the stamp duty in 1712, rather than overt licensing or copyright, that restricted competition among newspapers. But new forms of publication often upset the equilibrium. In the 1730s, the arrival of monthly magazines sparked a debate about literary property in periodicals. The Gentleman's Magazine, which first appeared in 1731, began its life by selecting and republishing articles from the weekly journals and tri-weekly newspapers. In this image from the title page, you see St. John's Gate, the printing shop of Edward Cave, and buttressing the edifice are the titles of the different periodicals that the Gentleman's Magazine drew upon in its compilation. The booksellers who invested in the weekly journals complained that Cave was infringing their property rights by reproducing articles from the weeklies. And much of this debate took place in a weekly called the Grub Street Journal. And when the editor of that paper took the side of the London publishers against Gentleman's Magazine, Cave responded by throwing the charge of piracy back at the weeklies. How could the weeklies accuse a monthly of unfair copying if the weeklies did the same thing to the dailies? Here you see an image from the news section, the satirical news section of the Grub Street Journal, in which the editor carefully reproduced verbatim short snippets of news on the same topic from a range of London papers using initials to indicate the source of each detail. Russell defended himself on the grounds of public utility, declaring, "Our method of comparing the articles of one paper with those of another is not only not piratical, but extremely useful and even necessary to put a stop to the currency of false news." It was an early argument for a quotation right. Russell's manual form of news aggregation exposed contradictions and showed that it was only by comparing the versions in several newspapers and laughing at them that readers could begin to make sense of the news. But Russell also made a more cultural argument. No man can assume to himself a property by employing persons to collect a heap of trivial, ridiculous, and false paragraphs of news and then publishing them daily to the world. But it's important to note that Richard Russell was in favor of copyright protection for certain kinds of periodical writings, such as poems, literary criticism, and essays. The fact that he excluded news is an early example of a principle that would gain traction during the 19th century. The idea that the rules related to the republication of periodical writings should be genre-specific. Now, attitudes towards copying have certainly evolved over time, but complaints often depend upon a perceived lack of reciprocity. In the early 19th century, the term scissors editors was used both to criticize those who relied too much on copying and to celebrate the virtues of careful selection, what we might now call content curation. In the early United States, the idea that newspaper articles were a shared resource had the backing of federal law. The first United States copyright statute in 1790 protected maps, charts, and books. The 1792 Post Office Act, which I see as a counterpart to the Copyright Act, encouraged the growth of newspapers by subsidizing their delivery to customers and by allowing printers to exchange copies of their newspapers through the mail for free. Some newspapers formed exchange lists with hundreds of other partners, enabling them to obtain reports from around the country and republish them for local readers. Editors did complain when their counterparts copied without credit, and sometimes retaliated by cutting off their supply of news or publicly shaming them in the press. Copyright was a blunt instrument for dealing with these sorts of relationships, and very few newspapers' editors gave it serious thought. However, the same could not be said about other periodicals that saw newspapers as engaging in unfair competition. Price currents were business papers catering to merchants. Given their specialized nature, it was difficult to imagine a reciprocal relationship with general interest newspapers. In 1828, the owners of a New York price current sued the owners of a daily newspaper in the same city for reproducing a regular column called the Review of the New York Market. You see on the slide that it has been entered according to Act of Congress. That is a signal that it is copyrighted or registered for copyright in any case. The publisher argued that he had lost many subscribers when these subscribers realized they could get the essential bits from the price current as part of a general interest newspaper. The interval of publication and the geography of circulation were crucial. The New York newspaper was able to insert material from the price current in its twice-weekly edition aimed at regional subscribers. This edition left New York City in the same mail as the price current, thereby completely obliterating any time advantage that the price current might otherwise have enjoyed. So there was a problem. Both newspapers and price currents were perceived as being very time-sensitive, even ephemeral publications, some said, and the judge in this case insisted that copyright statutes were meant to encourage learning, and he didn't see how reports about trade and markets did that. To determine the purpose of copyright, the judge referred to Article 1 of the US Constitution, which says that Congress has the authority to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their writings and discoveries. Now, in this clause, copyright was linked to the notion of science, and like other judges in the 19th century, Justice Thompson interpreted science to mean knowledge of enduring value. The term science, he wrote, cannot with any propriety be applied to a work of so fluctuating and fugitive a form as that of a newspaper or price current, the subject matter of which is daily changing and is of mere temporary use. Not just ephemeral in terms of form, but the subject matter is daily changing. So it was not the factual nature of the price current. It was the fact that articles were extremely time sensitive. This week's reports would be superseded by next week's. For the judge, the review of the market could not be a lasting contribution to knowledge in the same way as an encyclopedia or a map. This was to be a very influential interpretation of the purpose of copyright in 19th century America, until it was replaced by a much more market-oriented view towards the end of the 19th century. Like price currents, magazines had reason to complain about newspaper copying. Newspapers sought customers locally, or at most regionally. Magazines had wider ambitions. Noah Webster was a Federalist, and he envisioned his American magazine as a vehicle for national unity. This was, after all, the moment right at the ratification of the Constitution. And the quote on the slide captures the difficulty of exerting control over a publication that you want to unify the nation. How does something circulate as property? Webster was referring to the circulation of his magazine, but newspaper editors further circulated individual articles by reprinting them, often truncating or detextualizing them in ways that upset Webster. He was frustrated by what he saw as the fragmenting effects of a decentralized and unruly culture of periodical publishing. The problem for magazines increased over time as they invested more heavily in original writings and engravings. In the 1840s, a few American magazine publishers began paying authors for their work and demanded that newspapers desist from copying, unless they waited a reasonable amount of time and gave proper credit. Sometimes these warnings or complaints appeared in the text of the magazines and sometimes on their wrappers, which are extremely rare to survive, as in this example from Godey's Lady's Book, conserved in Philadelphia. Graham's magazine, also based in Philadelphia, made similar complaints, and the two publishers began registering each issue of their magazine as for copyright as books. When newspaper editors complained that this was a sudden change in editorial norms, Godey responded that they were free to reprint articles if they waited 1 month, when the next issue of the magazine was out. Now that's an early example of publishers recognizing that a lengthy copyright is not needed for periodicals and proposing a blanket license on condition of attribution. Such credited material could boost the reputation of a periodical and attract further customers. The publisher of a journal called the American Agriculturalist in the 1850s made such a license explicit. Here you see the copyright notice indicating that the work had been duly registered at the district court, but it's immediately followed by an invitation to copy any and all desirable articles as long as credit is given. He won't use the law if you play by his rules. If we turn now to France, I think we can see how the dynamics of periodicity, timeliness, and genre played out in a very different publishing environment and a very different legal culture. An interesting point of entry is the 1830s, which witnessed important changes in government regulations and the takeoff of serialization. As you see in this slide, several periodicals used deliberately provocative titles such as Le Voleur, the Thief, and Le Pirate, I don't think I need to translate that one, to celebrate their role as compilations that took the best material from other publications. The title Cabinet de Lecture similarly evoked the idea of a mobile subscription reading room, providing readers cheaper access to literature and culture through compilation. Well, the provocations of Le Pirate, whose subtitle was Collection of the Best Articles in French and Foreign Journals, led to legal challenges. A case brought by the Gazette Littéraire in 1830 went all the way to France's Supreme Court, or Cour de Cassation. And the main legal question was whether articles in periodicals constituted literary property. The second question that you see on the slide relates to the fact that in France, violation of literary property constituted the criminal misdemeanor of contrefaçon. So an accused party could be brought before a criminal court in addition to facing financial responsibility for damages caused to the injured party. The publisher of Le Pirate argued that the French decree did not apply to periodicals. They weren't specifically mentioned. He said, well, even if it did apply, it could not be considered contrefaçon for periodicals to republish articles, since this sort of borrowing was now an established custom. Finally, he insisted that for periodicals, the financial reward comes from being first to publish, and neither the publisher nor the author could be harmed by copying, given the short period of interest in each issue. In response, the Gazette littéraire insisted that French law made no distinction among works in terms of length or mode of publication. He argued that, quote, the property in the smallest writing is just as sacred as that of a long poem. And although the financial damages may seem small, copying remained a violation of the author's exclusive rights. The court indeed found that the terms of the statute had been respected. The Gazette littéraire had deposited 2 issues of each journal, and the pirate had republished without permission, so the publisher was guilty of contrefaçon and ordered to pay a fine and damages. The Cour de Cassation thus confirmed that articles in periodicals were literary property protected by law. But that begged the question of whether all the articles in newspapers and journals qualified for such property. L'Estafette, Journal des Journaux, the Journal of Journals, or the Newspaper of Newspapers, was another periodical that openly advertised its practice of reproducing text from other periodicals as its service to readers. Several newspapers initiated legal proceedings in 1835, and in its ruling, the court distinguished between 2 types of newspaper articles. News, which it defined as simple announcements of facts, which were more or less public knowledge in France and in foreign countries, and therefore belonged to the public domain, and literary or political articles, which were the result of intellectual work, and having them written, edited, and published entailed significant expenses for the owners, so it did constitute private property. You see here this distinction based on genre. The provocative behavior of L'Estafette also raised the question of the time-sensitive nature of newspaper articles. In another case, 1 year later, a local court reasoned that news articles were destined to be brought to the attention of the public, and that the harm caused by copying articles on political topics decreased in proportion to the length of time between the initial publication and the copy. The court decided that the solution was to impose an embargo, and the appropriate time would be the length of time that it took for the periodical to reach the farthest point in France. By that time, it must have reached its customers. The court estimated this to be 5 days and therefore prohibited L'Estafette from reproducing literary or political articles or letters from correspondence for at least 5 days after publication. Now, this concept of an automatic license after a short period was totally foreign to literary property laws, but it was an attractive alternative idea, given that the business model of periodicals and their mutual need to borrowing from each other. Although publishers were free to make such arrangements among themselves, they could promise not to sue if certain conditions were met. Courts did not accept custom of the trade as a defense if a literary property suit was brought. Indeed, in this same case against L'Estafette, the Court of Appeal rejected the whole idea of an embargo because judges could not arbitrarily determine potential damages in advance of an offense. Judges also could not reduce arbitrarily the duration of literary property established by law, which in France was already linked to the life of the author. The 1830s also saw the development of a new kind of newspaper sold at a lower price, supported by advertising, and using serialized fiction and nonfiction to attract readers. The feuilleton was both an opportunity and a headache for authors like Balzac and his contemporaries. They formed the Société des gens de lettres in response to a general climate of piracy that included Belgian counterfeiting of French novels, as well as unauthorized copying by the press. The Société des gens de lettres acted as a collective rights management body, negotiating contracts with periodicals and representing authors in litigation. So, although judicial recognition of the principle of property rights in periodical writings was recognized relatively early in France in 1830s, it was not enough to ensure effective protection let alone the bargaining power of authors in relation to the press. Collective action was seen as essential to making the syndication model of publication work. In Britain, the 1842 Copyright Act included specific provisions for reviews, magazines, and periodical works. Only the first number had to be registered to enjoy the benefits, and publishers of periodicals could claim property in contributions as long as they had paid for them and the work had been done by the author with the understanding that the copyright would belong to the publisher. Now that's a lot of ifs, and there's been a surprisingly little amount of research about how these new provisions were used in practice, how they may or may not have altered arrangements with authors and publishers. For our purposes, it is important to note that newspapers were not specifically mentioned in this law, whose preamble proclaimed rather majestically that the purpose of copyright was to afford greater encouragement to the production of literary works of lasting benefit to the world. So the time element, again, is raised. The publishers of newspapers recognized that lengthy copyright terms linked to the lifetime of the author were totally inappropriate and unnecessary for most newspaper articles. What was needed, they argued, was a copyright of a much shorter duration, perhaps 24 hours or 12 hours, just enough time to ensure that the newspaper that spent money gathering the news had a chance to gain some advantage. This idea was indeed proposed in the 1830s and in the 1850s in Britain in the context of the reduction and repeal of the stamp duty. The owners of London newspapers claimed that repeal of the stamp would lead to the proliferation of cheap newspapers that thrived on copying. They knew that the stamp had restricted competition to their benefit, and now they sought a copyright that would enable them to avoid ruinous competition with a cheap press. But the provincial press rallied successfully against this proposal, accusing a handful of London newspapers of trying to monopolize information at the very moment the government was trying to increase access to newspapers. By the 1850s, the telegraph was a factor, precisely because it was altering relationships among metropolitan and provincial newspapers. The Times and the Daily News sought a national audience. They did not like the idea that agents for the provincial press could come to London, copy news from the London papers, telegraph it to Manchester or Birmingham, and then print the news locally before copies of the London newspapers arrived by railway in those cities. The debate once again exposed how newspapers existed in relation to each other in time and space, and how attitudes towards copying depended on this dynamic. In the end, the government withdrew the proposal. It was simply too controversial. More important than the telegraph per se, then, were the different ways the technology was exploited to reconfigure relationships among publications. News agencies like Reuters in the UK and Havas in France hoped that copyright could protect their centralized model of news distribution. In 1861, Havas and one of its subscribers, the Journal du Peuple in Bordeaux, sued another Bordeaux newspaper, which was not a subscriber to Havas, for copying telegraphic dispatches. The Journal du Peuple wanted exclusivity in its city, or at least protection from a newspaper that was copying the news without paying for it. The local commercial court, following Havas's lawyers' arguments, reasoned that news of an event is undeniably in the public domain, belonging to all. But when this news is collected and transmitted by someone, it becomes their property, just as in the case of, quote, an object without an owner that someone is the first to take by the hand and then shape by their work, recreate by their industry, intelligence, or activity. The Lockean language of property belonging to the first taker based on their labor may seem very striking in a French context, but this was a commercial court deciding on a trade dispute. The court recognized Havas's property right, arguing that the protection of their investments was beneficial to the public. Without the agency's work and diligence, the public would not enjoy such rapid access to news. This seemed extremely promising for Havas, but it did not last long. The appeals court reversed the decision, insisting that literary property was reserved for works of the mind, which were, quote, the the product of the labor of the author, and convey, in some sense, the imprint of his personality. The court recognized that long-form journalism, which was then called and is still called in French article de fond, on political or literary topics could rise to this level, but not telegraph news, which was simply a faster means of bringing information to readers. The publisher who broke the news had the benefit of the novelty and could profit from that novelty, but once printed, other newspapers were free to copy, even verbatim. Havas appealed the decision, but the Cour de Cassation refused literary property for political, scientific, or literary news sent by telegraph, using two justifications. First, telegraph news did not rise to the level of creative authorship, and second, it was in the public interest for this information to circulate. This was a major blow for news agencies. The decision is also important for the broader history of copyright because it articulated more clearly than before the idea that works needed to bear the imprint of the author's personality to be eligible. That formulation, which came out of a dispute over time-sensitive information, was to have tremendous influence in the broader discourse of copyright law. A similar process actually took place in the very different environment of the United States. In the 1880s, the Associated Press, seeking to protect the exclusivity of the news produced by its members, lobbied for an 8-hour copyright for news. But this failed owing to vigorous opposition by newspapers in small towns and rural areas. A petition signed by hundreds of newspaper editors insisted, copyright and patent laws are not made to reward individuals or corporations for the expenditure of money. If only they knew, right? But to stimulate creative and inventive talent. If a copyright can be granted on news, it must be to him who creates or invents news, and not to the newspapers, which are buyers of and dealers in news. As the legal scholar Robert Brownice has argued, the mention of creative and inventive talent here is noteworthy because the threshold for original authorship in US copyright law during the 19th century was actually quite low, and the rhetoric of creativity was largely absent. But the effort to extend copyright news led critics to insist that copyright should be reserved for creative works of authorship. This distinction between news and other genres of periodical writing was reinforced by international copyright treaties, which emphasize protection for literary and artistic works. In the lead up to the Berne Convention, the provisions that would apply to periodicals were the subject of much discussion and debate. At the first meeting in 1884, it was the Haitian delegate, Louis-Joseph Janvier, who played an absolutely crucial role. Janvier was concerned because an initial draft said that articles in newspapers and periodicals would be open to reproduction in other countries of the Union. However, this automatic republication right would not apply to serial fiction or articles on science and art. On behalf of developing countries, Janvier argued that scientific articles in particular should circulate without restriction. He was ready to accept stricter rules for art and literature. He said those were good things and that developing countries needed those too, but they weren't as urgent as scientific and medical articles, which he said needed to be brought to the attention of all peoples of the globe for the greater benefit of each of them in as short a time as possible. Janvier also insisted that the countries making important scientific discoveries, such as France and Germany, had much to gain by allowing these discoveries to circulate, by allowing the scientists to become even better known as their writings and writings about them circulated in periodicals. Janvier's proposal to remove the word science was initially rejected, but he ultimately prevailed because the agreement adopted in 1886 removed the whole passage about serial fiction, science, and art. Instead, the 1886 agreement contained a general rule that articles in periodicals could be reproduced unless the authors or publishers expressly prohibited that in a notice somewhere in the periodical. In addition, this option of reserving rights was not allowed for articles of political discussion or to the reproduction of news of the day or what they called faits divers. This was essentially a positive right of reproduction for all articles that were not explicitly reserved. However, this clause made many people unhappy, and when the convention was revised in 1896, the reproduction of serial fiction was explicitly prohibited, and the reproduction right for other works was now contingent on attribution. There was still a positive right to reproduce news and articles of political discussion, though the latter category would actually be removed from the public domain when the convention was revised again in 1908. Now, the international protection was available for all sorts of articles in newspapers and periodicals, provided that the rights were reserved, with an important exception. News of the day could still be freely copied or translated. And yet, it is crucial to distinguish between what the treaty said and what authors, editors, and publishers did in actual practice. The negotiations of the treaties and legislation reflect the arguments of various interest groups, but there's surprisingly little research, once again, on how writers, editors, and publishers adapted to these new rules, whether they paid attention to them, whether customs and practices actually changed as a result of international conventions. We've all seen a lot of works that say there was no international copyright before 1886, but what happened actually after? Despite the universalist rhetoric that usually surrounds copyright, both in the past and today, we cannot assume that copyright is an on-off switch, or that the boundaries between private property and the public domain are actually clear. Periodicals make this evident in very interesting ways. And I think that the examples presented here indicate some of the reasons why periodicals have often had an uncomfortable relationship to copyright law. On a basic level, the business models of most periodicals did not depend upon having the exclusive right to reproduce and sell the same work over the course of years or decades, as was the case with many books. Rather, they were serial works with the goal of providing fresh material in each issue, thereby catering to a community of readers. There was a range of economic models, of course, but over time, a combination of subscriptions and advertising was central to the success of most periodicals. And that's a very different model than the model that is used by many works that are protected by copyright, which seek to sell the same thing to different people over time. The heterogeneity of periodicals also raised the question of genre, and while certain categories obtained relatively easily cultural and judicial recognition of literary property, others were excluded on the grounds of public utility or on the grounds of some kind of aesthetic insufficiency. Legislative proposals and litigation involving periodicals often led critics to describe them as ephemeral and to stress the time-sensitive nature of their components. The perceived ephemerality of periodical writings raised fundamental questions about the purpose of copyright laws, whose titles and preambles often referred to the encouragement of learning or the promotion of literature of lasting benefit. Periodicals' special relationship to the present, to the recording of political, literary, and scientific material in the present, thus raised interesting questions about the limits of copyright and what it was supposed to do. And as numerous editors and publishers recognized, periodicals were in dialogue with each other, and in some cases they were interdependent. And in those cases, what mattered was establishing some sense of reciprocity or shared norms related to copying and attribution, rather than treating all copying as bad. These customs were not necessarily recognized by lawyers and judges who were steeped in the technicalities of the law, but they certainly reflect the efforts of editors and publishers to exploit various combinations of periodicity and compilation to serve their readers in a timely manner. The business model of periodicals, their heterogeneity, their perceived ephemerality, and timeliness, and their relationships to each other. All of these factors tested the limits of copyright law. By limits, I mean not only the contested boundaries of the law in terms of what kinds of works are eligible for exclusive rights, I also mean the limitations of copyright in practice, what copyright was and was not able to achieve given the objectives and strategies of the people involved. In that sense, periodical publications could be said to have contributed to the evolution of copyright and authors' rights, while also challenging some of their fundamental premises. Thank you very much for listening.